All right. Good morning, Ms. Rivers. Are you able to hear us?
Yes, I am. Good morning.
Good morning. So let's first please have a quick conversation with Mr. Pritchett, and I'd like to have that on the record. So that's the case of 20SC176922. Mr. Pritchett went to trial a while ago, and there was a motion for new trial, timely filed. And Mr. Pritchett, good morning. Are you able to unmute there?
Yes.
Great. Good morning. I had you, and let me get you right there, added to this conversation this morning because we needed to confirm with you your plans for representation, whether for your motion for new trial, you were going to represent yourself, if you or your family would be hiring someone, or if Mr. Hewitt, who is on the call here, would need to be called upon to line up appointed appellate representation.
On my end, I am still currently confirming just private representation. Now, I did speak with the public defender office briefly a minute ago, as far as just letting them maybe at this point help with the process to the extent that is necessary and what is needed. But I know ultimately the ball is still really in as far as moving forward, it's still in the court's hand, because we at this point, I mean, I'm not aware of any transcript that has been produced regarding the trial, and I know that is needed to proceed forward with or without an attorney. I mean, of course, for the new trial. Is that not correct?
So certainly a transcript is necessary, and you, if you're representing yourself or your lawyer, is 100% entitled to it, and the ball doesn't really get rolling until there's a transcript. And so I guess in one respect, we can wait until the transcript's done and then reconnect with you and have you decide. It's just helpful for Mr. Hewitt's team if they know that they need to line someone up. There aren't a whole bunch of attorneys statewide who focus on appellate practice like this. So you don't need to commit right now. It sounds like maybe that's still a little bit in flux. I'm calling your case up right now just to make sure the transcript didn't sneak up on us.
It did not, Your Honor.
Okay. Mr. Armstrong's checked, and the last I've seen is there's an amended notice of appeal letter from you, Mr. Pritchett. There was one in April and another in May. So we are in this moment of pause. Ms. Rivers needs time to get the transcript done. But just typically what happens is we find out before then, all right, this is the lawyer for Mr. Pritchett. Here's who's representing the state. And we talk a little bit about scheduling. But that's more preparatory. You're right. Nothing can happen until that transcript's done, so that either you, if you're representing yourself, or a lawyer can pour over it to say, hey, here's where the judge made a mistake. Here's where whatever happened. So why don't you tell me right now which way you're leaning, and then we'll find out from Ms. Rivers what she forecasts for completing the transcript. I don't know where this falls in her list of cases that she's working on.
I like I said, just me confirming just the private counsel that I have and my family has been in contact with. Of course, nobody has entered any appearance on the case as of yet. But again, that is still being confirmed. What I will do, I think at this point, just thinking about the conversation that I had with the public defender office, I will fill out the necessary forms. I think for their procedure as far as retaining counsel, there is some type of forms or questionnaire that they needed me to do, just ultimately, if I was to lead in their direction, that needed to be complete to ultimately move forward. And I think that would have made their process easier if I was ultimately to end up in that route. So I know just I guess for them to be on proper standby and not just lingering, I guess I can fill those forms out for their offices. Ultimately, you know, if that is the route I will take, it will be ready, at least to be taken. But at this point, nothing has been confirmed.
Okay, I think I follow all that.
Your Honor, may I mention something just because it's a possible snag and I want to make sure? I assume it's something that in this division of the court is not an issue. But because he represented himself at trial, I wanted to point out that applying for public defender assistance is good for establishing indigency, because that is what Georgia law has as the marker that establishes indigency is the public defender's office. And both the formal request for a transcript to the court reporter, but also how the transcript gets paid for is determined by indigency. And so if he files the indigency form and that goes into the record, that directs the court reporter to file it regardless of whether they're paid for it by other means.
Got it. Okay. That's a helpful piece of advice. So, Mr. Pritchett, that's yet another reason for you to fill out that paperwork that would document, assuming it's accurate, that you qualify for appointed representation. The transcript will be completed. That's not what Mr. Armstrong was saying, but the question of how it gets paid for, if it has to be paid for, is driven in part by your financial means. If it turns out that you've got $100,000 on your books at Wheeler, then you're either hiring a lawyer who would be paying for that transcript, or you're representing yourself and you're paying for the transcript. But we aren't in that situation right now. Let me ask Ms. Rivers, who I know is writing things down, if she could give us a rough forecast of when she thinks the transcript in this case will be done.
Mr. Pritchett's case is actually next up to transcription after this.
I'm sorry, I couldn't quite hear that.
Can you hear me?
Yes.
Yes, Mr. Pritchett's case is next up to be transcribed after Sanders and Pittman, and I forecast that to be around August to be complete with both cases.
Okay, then why don't we do this, and then I want to hear from you, Mr. Hewitt, because we'll limit the number of times you need to plug in like this. It seems like if we got Mr. Pritchett and you, Mr. Hewitt, back on, and Mr. Armstrong or one of his colleagues in August, and Ms. Rivers and I work together, so I'll be checking in with her. But if it looks like that transcript is wrapping up, then we ought to get everyone together again, and that will truly be the crossroads for Mr. Pritchett, because he'll have more time to work through with his family whether they're retaining someone, or he will have completed the paperwork to get GPDC in the mix, and then he can let me know which of those three options, assuming he qualifies for GPDC representation, which are the routes he's going to pursue, and that will be an actionable clock will be ticking by then. There isn't anything we could do right now because there's no transcript, but by August there ought to be one. And so it'll be a little more pressing for Mr. Pritchett to say, hey, here's what I want to do. Mr. Hewitt, anything you want to add, or does that work for you?
That works for me. I just add just so Mr. Pritchett understands what I'm doing here. I'm not his lawyer. I'm the statewide supervisor of the appellate division. And so I'm just sort of hovering over this case. You know, if we do need to appoint somebody, then I'll get that. I'll make that happen. And but if he wants to go pro se, that's fine too. Or if he doesn't qualify, that's fine too. But
Right.
I'm just sort of here to try to facilitate things. And sometimes when I do these, the defendant thinks I'm their lawyer, but I'm not. Okay.
Nope. I appreciate you flagging that. I think Mr. Pritchett understood that you're in that supervisory capacity, and I appreciate him pointing out, hey, without a transcript, it's sort of moot right now. So I think that's where we are. Mr. Pritchett, anything you want to add? I had muted you because there was some background noise. You got to unmute.
Okay, there is one concern I do want to address, and that is regarding your response to the motion and the rest of the judgment that I filed. And honestly, Mr. McBurney, it does seem odd because the response to it was just pointing out my untimeliness for the motion that was filed, rather than discussing the issue at hand. And honestly, the timeliness was impossible. And it don't seem how it was constitutional. It does seem like it violated multiple of my rights because the judgment was entered May 2nd. The last date that I had to file that motion was May 6th. That was 4 days after you attempted to sentence me to football numbers. So it just, I don't see how it was just constitutional as far as you ruling in the direction that you did on the motion, honestly, sir. And again, like I said, the main issue wasn't at hand. You're trying to hold me to a standard as far as the timeliness and filing that I don't believe that even the court are holding the district attorney to, because the main issue at hand was, okay, well, is there, a record reflecting the return of the indictment in court? Heil stood up in a hearing. There is a record of this. I have the exact timestamp on one of the videos that you have on your YouTube channel of Mr. Heil stating specifically that there is no minutes. Minutes do not exist of the return of the indictment being returned in open court. That's not even how the process worked. And it really was a clear statement that was against the laws and procedures regarding that process. And so again, the issue at hand wasn't addressed, and I feel like I was being held to a standard as far as filing that I was just I couldn't do it, honestly, sir. And,
Okay.
and so I can there be some type of needs to be some type of reconsideration that I'm just kind of asking for as far as that motion is concerning.
So two things. One, that may be something that you or your appellate lawyer chooses to bring up when an amended motion for new trial is filed. But number two, I note in the record, you have already filed a notice of appeal of my order. So that's out of my hands. You have appealed it. You'll pursue that appeal, and we'll see where that goes. But I don't have jurisdiction over that order now because you have challenged it, and you will navigate the Court of Appeals channels consistent with that notice of appeal that you filed. So you, as I said, may end up weaving it into the amended motion for new trial. Can't do that till we get our transcript in August. But before then, you'll be able to continue to work on that appeal that you filed. Anything else, Mr. Pritchett, before we get Mr. Ponder into your seat?
Not at this point. Kind of call me a guard there, but I think that's on my end. I think that is it.
Okay, well, we will get you back onto Zoom in August at some point to see how we're doing with the transcript and to get a more final answer from you about representation. Mr. Hewitt, appreciate you joining us. You're welcome to stay for the Ponder one, but he's got a lawyer. His lawyer's sitting here in court, and we're going to pivot to that now.
I think I have plenty to do today. I appreciate the invitation, and like I say, if y'all have any problems, you can have Ms. Hansberry contact me on any of these appellate cases. I'm glad to straighten things out. That's what I do all day. Okay?
It is, and we appreciate your help. Thank you, sir.
Can I be excused, Your Honor?
Yes.
Okay, thank you. Mr. Pritchett, do you have something you want to say to me, or?
Mr. McBurney, can you just give me just a brief summary? Okay, after me filing the amended to your motion, what could I expect next as far as that process?
So you have appealed the order that I entered that dismissed your motion in arrest of judgment. So you see what else is in the docket. You had your notice of appeal. The clerk's office has sent to you some information. It's a checklist that you're supposed to complete They most recently sent a letter in May to you, and you'll work through that. That's what you need to do to ensure that the record that's relevant to the motion in arrest of judgment gets to the Court of Appeals.
And that's the problem. How do I get that how do I get the record? I mean, how do I get that record?
So the clerk's office transmits the record. You don't have to go around doing anything, but they sent you a checklist and they highlighted a couple things in that checklist that they're saying you did not include. And so you'll need to interact with them, not with me, about that. So you should be looking for that letter if you didn't receive it, although it was sent by certified mail and it looks like, so it should be there by now.
All right, appreciate it.
You bet. All right, if you could get Mr. Ponder, please.
Thank you, Your Honor.
Thank you, Mr. Hewitt. All right. Good morning, Mr. Ponder. Can you hear me?
Good morning, sir.
I'm Judge McBurney. I don't think we've met many times, if at all. I am not the judge who presided over your trial. That judge is not a judge anymore. But I am the judge who received your case by random assignment when you reached out a few months ago saying, hello, what's happened with my motion for new trial? And the answer sadly was nothing at all. And so several decades passed since the time of your trial and conviction and sentence. And we are very, very belatedly taking up the question of how did that trial go? Were there errors that were committed that were sufficiently prejudicial to you that you ought to get a new trial? Mr. Winchester agreed to take your case. I very much appreciate that. And he has filed an amended motion for a new trial on your behalf. And we are this morning going to receive a little bit of evidence. I think your trial lawyer is on this call, so she may be answering some questions. And it may be that Mr. Winchester has some questions for you. We've got a prosecutor on the call as well. We're going to receive all that evidence and argument today, and then I'll enter an order. If my order grants the motion for new trial, then that could mean that we redo all this 20-something years later, although the state has a right to appeal a ruling that grants you a new trial. If I deny the motion, then you will at long last have argument made before our Supreme Court, given that you were convicted of murder. And the Supreme Court will take up all the same issues that are being discussed today, along with anything else Mr. Winchester thinks they ought to be thinking about in connection with your trial. Does that make sense?
Yes, sir.
Okay, I'm going to mute you now. You should unmute and wave your hands and interrupt if you can't hear what we're doing or you've got a question about what's going on. But the facility there generates a little bit of background noise here. So unless we're needing to get responses directly from you, I'm going to leave you on mute, okay?
Yes, sir.
All right. So, Mr. Winchester, I understand from reviewing your amended motion for new trial that you are raising several grounds. I want to articulate them as best as I understand them. And then you can tell me, yep, we are persisting with those, or oh, now that I've seen the state's response, I'm withdrawing those, or hey, I came up with some new ones last night while I was thinking about the case. At the most fundamental level, you're challenging the sufficiency of the evidence behind Mr. Ponder's convictions on counts 4 and 13. Those are 2 aggravated batteries, loss or deprivation of stomach and colon for Ms. Brown, and kidney for Mr. Pitts.
Yes, Your Honor. I didn't plan to dedicate much time to that, but yes, we're not going to waive that.
Okay, great. I understand those. And you're going to allocate your time as you see fit. I'm just making sure I'm understanding them. There's the obvious one. What are we doing here 20 years later? So the due process right violation that might flow from a double-decade delay in getting to a hearing on a motion for new trial. Couple errors by the trial court are alleged. One is instructing the jury that witness intelligence is a permissible factor in assessing witness credibility. And the other was a sua sponte charge from the trial judge about how to manage conflicts in testimony. Is that correct? Those are both errors you're asserting? Okay. And then ineffective allegations in that Ms. Good failed to request jury instructions about heat of passion and provocation, and something about, you say failing to invoke, and you'll articulate this more, I'm sure, when we talk about it, the modified merger rule when the first verdict came out and the trial judge rejected it, and the jury had to take that back. So those would be the 2 grounds of ineffective assistance. And then finally, there are some claims about sentencing errors. I think the judge said I merged the felony murder into the malice murder rather than vacating it by operation of law. And some failures to merge ag assaults into aggravated batteries. I think they may actually have happened, but the forms back then were complicated and hard to follow and multiple pages. So we'll talk about all that, and it may well be that in cleaning up the statement that it's a merger, but it's actually a vacatur, that I just enter an amended sentence in the new and improved form. Well, it's all very clear, because I think the judge's intent was to merge the aggravated assaults into the aggravated batteries, but it's just murky on those forms. And then finally, you challenge the trial judge's failure to merge the collection of firearms convictions. There were 4 such convictions, all involving the same gun, but 3 different victims and then a couple different crimes.
I may be withdrawing 8. I've seen the state citation to Marlowe, and I think that is a valid response to that, given that they involve different victims.
Okay.
But as to 6 and 7, I think 6 is going to be conceded, and then 7, I've seen the excerpts that they've pulled in the response, and if that's what the documents reflected, and I was confused going through the disposition, I think we all wind up in the same place. But
Right. I didn't hear the state saying there should not have been a merger. I heard the state saying there was, but you have to have your computer on 200% magnification to read that document.
If I missed that, I think we all get to the same place.
Okay, but 8, the challenge to the multiple convictions for firearms possession or firearm in connection with a felony, you're withdrawing that.
Yes, so the way I understand the law is that if it's multiple gun charges arising from one gun and one transaction against one victim, they would all merge. But since they're different victims, there's permissible multiple convictions.
Right, we have 3 victims. The evidence demonstrated, and it sounds like Mr. Ponder admitted that he shot Ms. Brown, Mr. Pitts, and Ms. Moore. So that would support the 3 separate convictions for the 3 different victims. And then there's that 1 additional firearms count. Okay, then why don't you, well, let me see if there's anything procedurally from Mr. Armstrong.
2 things. First, I wanted to apologize to everybody, including the victims, that I confused Ms. Moore, Ms. Brown in the state's response. And so I will clarify that as needed, but it sounded like from the court's recitation of what happened that would not have misled the court.
It confused me initially, but then I was unconfused because I realized you just got some names flipped around.
Yes.
Okay.
The second thing is, Your Honor mentioned a claim that I did not see when I reviewed this before, and looking at the motion for new trial, I don't see now. I don't see a claim, but I know it's been raised in another case, and so I was confused as to how I could get the 2 cases confused. The rejecting, telling the jury to send something back because of, it's not the modified merger rule, it's the idea that the jury returned verdicts on both things and told them to send it back, is what I understood the court to say. I might have to ask for an opportunity to respond to that later because I did not see that in the motion for new trial.
Look at 5B. I just reading from 5B. When I was preparing last night, I didn't focus a whole lot on the ineffective assistance piece only because that gets fleshed out through the witness. And so I only skimmed it. I read it in more detail just now when I was canvassing the claims with Mr. Winchester, because sometimes when we get to this point, he says, hey, I'm withdrawing one because I've thought about it more, or now that I see the case from the state, why would we pursue this? So 5B, I may be misreading it, but
no, I think you're reading it correctly. I understood whenever anybody invokes the modified merger rule, it's typically about instructions. And so I might have misinterpreted it, and I see what you're reading.
Me too. I thought it was about the instruction, but the way this is articulated is it is a claim that Ms. Good should have, when everyone received the verdict and Judge Brogdon was asking the lawyers, what do we do with this? As I'm understanding the claim, Ms. Good at that point should have said, look, you need to invoke the modified merger rule. So it's not instruct the jury something to do something. It's here's how we need to accept and process this verdict rather than rejecting it and sending it back to them. But I'll let Mr. Winchester flesh that out more.
So that's correct. It's about how the first verdict form was handled. I think the state's right that the nomenclature of modified merger may be wrong, but the act of what I'm challenging is the receipt of that first verdict.
So the first verdict, the jury found Mr. Ponder guilty of both murder and voluntary manslaughter.
Correct. So I think reading over this more delicately, it's not modified merger because we're not dealing with felony murder. But there was a guilty verdict on malice murder count 1, and there was a guilty verdict, lesser included voluntary manslaughter.
Okay.
Yes.
Got it. And what the record shows is that Judge Brogdon, after talking with the lawyers, told the jurors, this is an inconsistent, told them something, and they went back to work. And clearly what they did was all right, malice murder, not voluntary manslaughter. And here we are.
Right.
Okay. Got it. But you're not challenging what the judge did in connection with that. I haven't seen an allegation that the court erred. Your challenge is that there was something ineffective on Ms. Good's part in the way she managed that interaction with the court.
The way I understand the waiver rules, when the court gives counsel an opportunity to raise an objection to his proposed procedure and it's not interposed, it's then waived, and if it's waived, then my avenue is ineffectiveness.
Got it. Makes sense. Okay. Anything else, Mr. Armstrong?
No, Your Honor.
Mr. Winchester, you're up.
Thank you, Judge.
You are welcome. Because Ms. Rivers is handling this remotely. You can be at the podium, you can be at your seat. When you're asking your witness questions, some lawyers say, I need to stand, and that's fine with me. I just need to know where you're going to be so I can make sure that camera's on.
All right, I'll stand because I think we'll have one live witness today.
Okay.
All right.
Live witness as in someone coming in the,
Mr. Hort, he's gonna be our second witness.
that's going to be interesting. Okay. Should he step outside so his testimony isn't tainted by your first witness?
Okay, we can.
I don't know what Mr. Hort's going to be talking about. I didn't know he knew Mr. Ponder.
I'll invoke the rule, just.
There you
make a
go.
plan.
Get out of here, Hort.
All right, at this time, we will call trial counsel, Ms. Doris Good.
Good morning, Ms. Good.
Good morning, Your Honor.
Thank you for being here. I appreciate your time these many years later.
Well, thank you for allowing me to appear virtually. I'm feeling a little under the weather, so I didn't want to get anyone sick.
Well, we all appreciate that, and I appreciate Mr. Armstrong going with that flow. So I'll let you swear her in.
Thank you, Judge. All right, could you raise your right hand? Do you solemnly swear the testimony you're about to give before this honorable court this morning will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, thank you, ma'am. Could you please introduce yourself for the court reporter?
My name is Doris Good, and that is Darice, last name Good with no E on the end.
All right, and Ms. Good, how are you employed?
I am self-employed as an attorney.
Okay, can you give us some background about how long you've been practicing law, what type of law you practice?
I started practicing law in 2000, so 25 years ago. At this time, I continued practicing criminal law. The only cases I address in criminal law is if there's child victims, and then probably 90% of my work is dependency and termination of parental rights in juvenile court.
Okay, and in your careers in practicing criminal defense, did you ever work for the Fulton County Public Defender's Office or Metro Conflict Defender's Office?
I did. I worked with Fulton County Public Defender's Office from November of 2000 to September of 2004.
And what was your role there?
I was an assistant public defender.
Okay, can you ballpark how many felony cases you tried during your time working there?
24.
Okay, and how many of those 24 were murders, if you had to specify?
I want to say 4 or 5 were murder cases. Mr. Ponder's case was the first time I was first chair on the murder cases.
Okay, so you've alluded to representing Mr. Ponder. Can you recall, I know it's been some time, but can you recall how you came into representing Mr. Ponder, what you did to prepare for trial?
Yes, I was appointed to Mr. Ponder through the Public Defender's Office. We have basically a series where you go through preliminary hearings and then you get moved on to the trial division. At that time, I was assigned to Judge Brogdon and had been in his courtroom about 2 years before Judge Brogdon solely. And so essentially, as far as the regular process goes, we investigated the case, we met with the witnesses. I believe we also had an opportunity to talk with the victims in the case and the family of the victims. And then obviously preparation of cross and direct examination of witnesses. We met with the medical examiner, discussed the case with the officers on it, in particular the lead detective. Trying to remember, prepared legal arguments, researched legal arguments, and did pretrial. There were several pretrial motions, if I remember correctly.
Okay, and if you had to characterize the theory of the defense when the case ultimately went to trial, how would you explain it?
I'm sorry, I didn't hear the first part of that.
If you had to characterize your defense theory when you tried the case, what was the defense for Mr. Ponder?
It was involuntary manslaughter.
Okay, so was serious provocation and heat of passion a part of that theory?
Absolutely.
And can you recall what specific facts you were relying on to convince the jury that this was a mitigated homicide?
There was multiple arguments about money. Mr. Ponder essentially financially supporting her. There was infidelity in the relationship by her, and then her continuation after that of constantly asking for money.
Okay. And in was requesting pattern jury instructions, non-pattern language, jury instructions on the provocation topic consistent with your trial theory in framing voluntary manslaughter for the jury?
Yes.
Okay. And do you recall which, if any, jury instructions you requested on that mitigation, sudden heat of passion topic?
From my memory, and I think from the transcripts in which I read through, the only one we requested was the form jury instruction.
Did you, when you went, now in preparation for this hearing, were you provided copies of the trial transcript?
Yes.
And have you reviewed the excerpts of volume 2 that show which jury instructions the judge gave?
Correct.
Did you see any jury instruction in that excerpt that told the jury expressly, if they found it was a heat of passion killing, that the verdict was manslaughter and not murder?
Yes, I do believe it was the form jury instruction. I can double check that. Okay, it's not right on that, but I believe it was in there. If you could point me to the right page, I could look at that. I apologize.
It's okay. To refresh your recollection, I'm referring to trial transcript volume 2, page 566.
Okay. I have it on file. There you go.
You said 566 or 56?
66.
Yes, it looks like I did. When he defined voluntary manslaughter, and that it would be considered voluntary manslaughter and not murder if it was a result of sudden, violent, irresistible passion.
Okay, so is it fair for me to describe that the pattern charge beginning at line 13 defines the crime of voluntary manslaughter?
Yes,
And then the subsequent charge beginning on line 21 defines revenge?
correct.
In reviewing those charges, do you see any other language that links the heat of passion topic to some of the facts of Mr. Ponder's case, like heated arguments, like infidelity, or mutual combat?
I believe I'm frozen. I think I froze for a moment.
Meaning you were trying to answer and we couldn't hear you, or what?
The last question I answered, and my last answer was there was nothing specific in the instructions that defined the provocation.
Okay.
So I don't know if there was a question after that. I apologize. It says I have good internet connection, but it's being a little iffy.
If there's any choppiness, just let us know and I can re-ask the question. In your recollection of preparing for the charge conference in this case, did you do research on on non-pattern language to try and link those factual bases for voluntary manslaughter to the topic of provocation?
Not to my knowledge, no. We went with the pattern instructions.
Okay, and reviewing some of those excerpts that you and I have discussed via email, are those consistent with your strategy at the time of trial in this case or inconsistent with that?
So can you identify which ones, the ones that you sent me that were additional instructions or the ones that were the pattern?
The three excerpts, did you receive an email from me yesterday with 3 case law excerpts in it?
Correct.
Have you had an opportunity to review those quotes, those cases?
Yes.
And do you have an opinion whether those excerpts are consistent with your defense that you actually pursued in 2004?
Yes, they are consistent with my defense.
Okay. Now, at the time of the trial, do you recall the jury's deliberations coming out with an initial marking on the verdict form?
Yes.
And can you explain your recollection of what occurred when Judge Brogdon showed that verdict form to the lawyers?
So they came out with a verdict form where they marked both voluntary manslaughter and murder. And in discussing it with the judge, it was our belief that they couldn't come out with both and that they had to decide one or the other. Our position was to send it back in hopes that they would find voluntary manslaughter and not murder.
Okay. In that sidebar, that bench conference that's reconstructed, do you recall whether there was any legal research or cases discussed before the parties kind of jointly arrived at that conclusion?
The only thing I remember in particular was the mutually exclusive verdicts. And the only reason I remember that is because of an armed robbery case that we had just done where that was an issue as well. As far as legal, case law being cited, no.
Fair to
I think
say, is
I'm
it fair
sorry.
is it fair for me to say that if you had or were aware of any authority that would have allowed the judge to accept that verdict, would you have accepted it?
Yes. If it was
Okay, and-
voluntary manslaughter, yes.
Okay. Now, after the case goes to conviction, do you recall what, if any, post-conviction communications you had with Mr. Ponder once he was sentenced?
I don't remember the actual. I'm sorry. Yeah, I don't remember the actual content except for inquiring about the appeal itself. And the reason I remember that is because I left that office in September of 2004, and I did get letters at my new office, which would have been after the sentencing. So I left September 4th. So I essentially left 2 weeks after this trial.
Okay. And was letter your primary form of communication with Mr. Ponder?
Yes.
Did he try and communicate with, do you recall whether he tried to communicate with you in any other way beyond sending you a letter?
His mother may have contacted me, but I can't be sure. I had a lot of contact with his mother throughout the whole entire time.
Do you recall, without telling me what she said, do you recall whether that contact continued after he was sentenced and sent to prison?
I'm not positive.
And when you mentioned that you had received letters at your new office, can you quantify, are you able to quantify how many you received?
There was a couple. I would say at least 2 or 3, because
Okay.
I know it took some time for them to appoint an appellate lawyer.
Okay. In between the timing of the appointment and your testimony today, do you recall any other subsequent communication with Mr. Ponder or his family?
I do not.
Okay. I think it's
I
all
don't
I have now.
recall. I don't know if he did or not, but I don't recall whether he did. It's obviously 21 years. So
Thank you, ma'am.
You're welcome.
Mr. Armstrong, do you have questions for Ms. Good?
Yes, Your Honor. Ms. Good, good morning.
Good morning.
And I just want to make sure, because like it's fun to get to say something like this every once in a while. You work at the Good Law Firm.
Yes. Yes, I do. It's a
So-
great name for being a lawyer.
Yes. I wanted to ask you certain questions about the issues that were just raised with Mr. Winchester. When the jury came back and had two different verdicts for one count, were you aware at the time of any case law that said the court was unable to send that back to the jury to have them pick one rather than both?
No.
Are you today aware of such a law?
No, only because I haven't dealt with that issue since that case.
You say only because. Could it be because it doesn't exist?
I don't know.
Speculation.
Okay.
Great.
I don't know. I'm sorry.
You filed a timely motion for new trial on behalf of Mr. Ponder in this case, correct?
Yes, I did.
Okay. Earlier today, there was some back and forth regarding the instructions on voluntary manslaughter and heat of passion. When he asked whether you had asked for instructions on the heat of passion element of voluntary manslaughter, you responded that here is the instruction that was the form instruction for voluntary manslaughter, and that's it, correct?
Correct.
Okay. And so you had received an instruction on voluntary manslaughter that you'd requested.
Yes.
Okay.
Yes. Yeah, obviously, yes.
Okay. No further questions, Your Honor.
Mr. Winchester, any follow-up?
No, Your Honor.
All right, Ms. Good, thank you so much for joining us. I hope you feel better.
Thank you.
And
Obviously, I apologize to Mr. Ponder. I had no clue that there was this delay.
no, I appreciate you saying that. And I don't think anyone has intimated that. You necessarily passed the baton after you file your motion for new trial. And the reasonable assumption is that steps are being taken for appellate counsel to be put into place. And I'm sure we're going to hear more about that when Mr. Winchester gets Mr. Hort on the stand. But the system failed. There's not another way. There's not a good gloss on that or a happy gloss. The system failed. The question we need to work through is, well, what are the consequences of that? And Mr. Winchester has teed that up. And I will need to work through it. But you represented Mr. Ponder at trial, worked with the evidence you had. From my brief review of the transcript, you didn't have much. And so you argued what you could, which was that this was a heat of passion, not that some other person did it or it was self-defense. Those options weren't available for you. That's not what the evidence presented. So there we are.
All right. Well, thank you. And may I be excused?
Yes, ma'am. Appreciate it.
Good luck, Mr. Ponder.
Would you like your next witness to be brought in by the deputy?
That would be great.
All right. It's gone far away. Morning.
Raise your hand. You swear affirm that testimony you give be the truth, the whole truth, and nothing but the truth of God. Put it in that seat. Can you state and spell your name for the record?
David Hort, Hoort.
And before we dive in, just a quick different case scheduling update. I just got the email from Ms. Hansberry. We were going to convene on Wednesday, next Wednesday, but there's an issue on the GDC end of things in terms of getting Mr. Singleton on screen. And so it's been moved to Friday the 13th. More time though, bigger window, but Friday the 13th.
I've been a good fan of Friday the 13th.
Well, it depends which side. I mean, maybe it's bad for the other side. Who knows? Your witness.
Thank you, Judge. All right. Thank you for being here, Mr. Hort. How are you employed?
Self-employed.
Okay. Are you an attorney?
Yes.
And what kind of type of law do you practice?
I need there should be a way to mute that. Is that muted?
No?
I think it's mine up here.
Nope, it's not yours. Can you hit over there?
We're good.
Right now, my only and last case is a appeal case with Judge McBurney.
Okay. So fair for you to say that you practiced felony criminal appeals?
Yes, well, I did, started out as an assistant prosecutor in Michigan, then became a defense attorney, which was doing trial work and appeals, and then was a judge for 25 years, then went to work for the Attorney General's office, came here to Georgia to be closer to our daughter, and as such, then I started working with the Georgia Public Defender Council, was a supervising attorney for the 5th District. After that, I left, and then Judge McBurney asked me if I would do the Singleton case, somewhat like he asked you to do the Ponder case.
Okay. And when you were asked to handle the Singleton representation, had you already conducted an investigation into languishing cases then or formally handled by the Fulton County Metro Conflict Defender's Office?
Not per se. I handled cases that were handled by the Fulton County Public Defender Office.
Okay. But I'll just ask it more broadly. Did you conduct an investigation into languishing post-conviction cases that were handled by that office?
Yes.
And did that investigate, was that limited to the Singleton case or did it range to other cases beyond Singleton?
I had many other cases in Fulton County, also in Paulding County, Barrow County, and it seems like one other, but I'm not remembering the name of it.
Now, with respect to the Fulton County cases, what did you do?
As an appellate attorney?
In your investigation, when you're looking into these old cases that have not yet come to fruition at the motion for new trial stage, what are you doing?
Okay, I'm talking with the client, and many times you can get insight, sometimes not always accurate, but at least avenues to pursue. Then I look at the transcripts. I also try to get what I can so far as the defense attorney trial file, any information that I can get that kind of raises red flags.
Okay. Was one of the clients that you wound up speaking to Robert Ponder?
I never spoke with him per se, but when I was doing the Singleton case, the trial attorney, Gary Gashardis, passed away. The appellate attorney, Carl Greenberg, has mental health issues precluding his testimony. And the second chair was 77 years old. So I started to look at other possible ways of showing to the court what went wrong in the Singleton case. And then that started my research.
Objection, Your Honor. That's non-responsive to the question because the question was about his contact with Robert Ponder.
Okay. Maybe it was getting there. It may have been a long answer, but that was the question was, did you speak? You said, I never spoke with Mr. Ponder. So why don't you continue to explore Mr. Hort's connection to your case?
Okay. Did you communicate with Mr. Ponder in writing?
Yes. Doing my research, his was one of the cases that came up as to Carl Greenberg. So I sent out a letter explaining what we were doing in the Singleton case, also enclosing a subpoena if that person would be willing to testify as to Carl Greenberg in the Singleton case. Mr. Ponder responded.
Objection, Your Honor. Are we waiving? I apologize.
It's okay.
This began with a flare of the attorney-client relationship, and now we're going to talk about a communication with a defendant I just want to make sure that they are waiving the attorney-client privilege before this person talks about his communications with the defendant on the stand, because I don't want there to be an issue with that if I ask cross-examination questions.
Fair point. So this is an unorthodox posture we're in. Were you aware, Mr. Winchester, that Mr. Hort was communicating with your client?
Yes.
Okay, and it's something.
Well, before he was my client.
Okay, so some of this happened before you were brought on board to of course, Mr. Ponder's been without a lawyer actively representing him for a couple decades now. You have since been made aware that Mr. Hort and Mr. Ponder were communicating.
Correct.
Okay. If Mr. Hort's going to talk about any of the communication provided by Mr. Ponder that opens some doors for cross-examination, do you have any concerns about that? Or I trust you know what Mr. Hort's about to say. Hey, your client said X, Y, and Z. I'm not going to preclude Mr. Armstrong from saying, well, what else did he say? And did he say something about this? Because you then suddenly invoke, well, wait, that you can't ask about what my client said.
Well, I don't have a problem with it because Mr. Ponder is also going to testify to the communications.
Well, then we're done. If Mr. Ponder's going to talk about it, then obviously Mr. Armstrong can explore it.
Right.
Okay. I didn't know that piece.
Of course.
Okay.
Can I continue my answer?
Why don't you ask the question again, just so we're back on track?
So, question was, did you communicate with Mr. Ponder in writing?
Yes, there were cases with Greenberg where he didn't do anything. Cases where even what he did wasn't anything.
Objection, Your Honor. This sounds like he's making opinions about what Mr. Greenberg did in other cases, not just Mr. Ponder's case.
Okay. I'm going to let Mr. Hort explain. I think he's providing context as to why he's talking with Mr. Ponder. I appreciate it's his opinion. I'm going to let him express that as we get to hopefully the point of the communications.
Mr. Armstrong wants me to, I could probably qualify as an expert witness.
We don't need to do that. We need to hear about what you and Mr. Ponder discussed through your correspondence.
Okay.
Did your letters, first and foremost, can you quantify how many letters you sent to Robert Ponder?
I am guessing there were maybe 2 or 3. The first one with the subpoena, and I think the second one, I'm not sure if the one that I gave you is the second one or if that was the third one.
Okay, before we get to the second letter, you mentioned that there was a subpoena enclosed in the first letter.
Yes.
For whom did you draft the subpoena?
For the Singleton case.
But the subpoena would have been for Mr. Ponder. It would have been, hey, would you please come, or you're directed to come testify.
All right. And in each of the letters that you sent Mr. Ponder, did you advise him to file a motion for appointment of counsel?
I don't think I did in the first one, but I'd have to look at the letters to make sure. I think I brought them with me if you want me to.
Okay. Your Honor, may I approach witness?
You sure can. If you're going to show him something, make sure Mr. Armstrong's seen it too.
I'm showing the state what I'm going to mark as defense 1.
My file there may have other letters if you want to look at it. And I can just a copy of that letter for Mr. Armstrong if you wish.
I apologize. I just have to read it because I haven't.
That's
taken it
okay.
before. And I am unfortunately not a fast reader.
Mind if I?
Please.
Thank you. Do you have a copy of it?
Yes. All right, I'm approaching the witness. What I marked is defense exhibit 1, or will mark as defense 1.
Okay.
Mr. Hort, do you recognize that document?
Yes.
What is it?
It's a letter I sent to Mr. Ponder on August 17, 2024.
Okay, and is that the letter that you're referencing when you stated you communicated with him and advised to file a motion for appointment of counsel? All right. Do you see any alterations from that from the time you wrote it?
No,
And where did that come from your file?
yes.
All right. At this time, I'll move to admit defense one.
Mr. Armstrong, any objection to defense one?
I object for the information contained in it coming in for the truth of the matter asserted, but for whatever purpose they're trying to get to as far as what Mr. Hort communicated to Mr. Ponder, I do not object.
Okay. So it's admitted, at least in form, and we'll see where we go with it.
This is, and to be clear, this is offered to prove that there was communication and advice made by Mr. Hort to Mr. Ponder.
As opposed to the substance of the letter.
Whatever opinions there may be about what has happened or things like that, that's not the purpose.
Okay.
So did you, in your written communications with Mr. Ponder, did you provide advice, or excuse me, pre-written forms for motions for out-of-time appeal and a motion for appointment of counsel?
No, I did not send him any forms.
Okay. Did Mr. Ponder write you back?
Yes, this letter actually is in response to his letter.
Okay. Who wrote who first?
I believe I wrote him first, telling him about the Singleton case and then enclosing the subpoena.
Okay.
And I think he wrote me back and then I sent him this letter.
And were there any duties as a part of the Singleton case to discover some of these other languishing issues in other cases?
I felt there was a duty on my part as an attorney because, again, passing trial counsel, the mental health issues of appellate attorney, I thought exploring other cases would provide intrinsic or extrinsic evidence to the court for the Singleton case.
Okay, so you mentioned mental health issues of the appellate attorney. Do you know who the appellate attorney was in Mr. Ponder's case?
Same attorney, Carl Greenberg.
Okay, how do you know, upon what basis do you make the statement that Mr. Greenberg has mental health issues?
Objection, Your Honor, hearsay.
I asked what his basis was.
You can answer the question as to what your basis is.
We,
I assume someone told you, which would make it hearsay, but the question isn't what were the opinions, it's how'd you.
when we were going to subpoena him to testify as the witness, his wife contacted me and told me about the mental health issues. I said, I'm going to need something from this doctor. He's not able to testify.
Okay. Rather than going deeper into any conversations with Mr. Greenberg's wife, I'll ask this. Did you ever send a subpoena to Mr. Greenberg to testify in the Singleton case?
I believe we did. The record would show online if we did, but my memory is that we did. And then that is when the wife then contacted me.
Okay. And ultimately, was Mr. Greenberg an available witness or an unavailable witness for that proceeding?
Unavailable because of the mental health issues.
Okay. And was there ever any documentation or medical support provided to you to substantiate the mental health diagnosis of Mr. Greenberg?
Yes, we did get a letter from the doctor, and that was entered into evidence in the Singleton case.
All right. If I had a copy of that, would it refresh your recollection? Would you recognize it?
Yes.
Okay. I'm going to show the state what I'm going to mark as defense 2.
Your Honor, I know that is what it was introduced in the other case. There's no issue the state's going to raise that Mr. Greenberg or another appellate attorney should have filed a motion for new trial. Since then, I don't know that any of this is relevant or necessary.
It is relevant because the Supreme Court may say, why didn't you subpoena Greenberg to explain why he didn't file the motion? So I think Mr. Hort is relevant to show that Greenberg's an unavailable witness.
Did you try subpoenaing Greenberg, or you spoke with Mr. Hort who said it's not going to work out and here's why?
So the latter, but I also spoke with another witness who said the same thing, or another attorney who said the same thing.
Saying that you will be unsuccessful in trying to get Mr. Greenberg here because of.
Correct.
Okay. And so what you're just trying to establish is why Mr. Greenberg's not here now?
I don't want there to be an allegation of failure of due diligence for failing to complete the record with Greenberg's testimony.
Okay. Any concerns about that, Mr. Armstrong? I don't get the sense that the state will be pushing back in that area. Just to preview what I've heard, or to summarize what I've heard, I suspect there'll be more, but on the Singleton side, the focus is more on the prejudice to Mr. Singleton, the things he can't do now, and not, oh, wait, but Greenberg this or Greenberg that. I mean, there's plenty of Greenberg failed to do X, Y, and Z,
Right.
but the state hasn't said, oh, no, he did do all these things, you just didn't find them. He was an absentee attorney for a long time, for different reasons.
Correct. That's my only purpose with this. I'm not
Okay.
trying to go any deeper than that.
All right. I don't want you to have to waive anything, Mr. Armstrong. Tell me where you are on this issue.
We have agreed that the first prong of the Barker versus Wingo for the speedy appeals is met. Motion for new trial should have been amended and resolved long ago.
Okay.
That's not an issue. The issue that Mr. Winchester has mentioned about the appellate court saying you need to bring in an attorney to testify is specific to ineffective assistance of counsel. This is not an ineffective assistance of counsel claim. This is a due process claim that is independent of ineffective assistance of counsel.
Respectfully, that's not.
Just let him finish.
Okay.
So I don't understand what the relevance to any of the issues about Mr. Greenberg or whoever represented them since then. I will let the court know I raised this as a defense attorney as ineffective assistance of counsel, and that really didn't produce anything beneficial, even though I showed 10 attorneys did literally nothing in a 10-year period of time for a defendant. It's the due process issue. He was supposed to get this resolved before. He didn't. That's the first prong. That makes sense.
Okay. Your turn.
So correct, it's not ineffective assistance, but I still bear the burden of proof as to all four of the Barker factors.
Mm-hmm.
The conceded factor is length. That's factor number one. There's not a concession as to responsibility for the delay, reasons for the delay, and weight that factor number two carries. That's still my burden of proof. So I think rather than just have an evidentiary void, where's Mr. Greenberg, I'd like there to be some testimony or offer of proof that he's not an available witness.
Okay. I will, if you have more, you can ask about that, but I think you've made a record that what happened in Singleton, that there were efforts to subpoena him and they were unsuccessful because of Mr. Greenberg's medical situation.
Okay. And given the discussion, I'm just going to move to admit this as defense two at this time.
Okay. So I understand the relevance objection, but I'll admit it. I'm going to need a copy of it. I'm going to need defense one. I can get that later, but these things I need to give to Ms. Rivers as she compiles the transcript. So I don't know how you want to get me defense two.
I can send an email.
Great.
May have put one in the folder there. I don't know. If
All right.
And defense two is the letter from Dr. So-and-so saying Mr. Greenberg cannot come testify.
Correct. As it pertains specifically to Mr. Ponder, did you have any other involvement in the post-conviction investigation of his case?
just telling him that he needed to file a motion for appellate attorney.
Okay. In your investigation of Mr. Ponder's case, did you review the record of his case?
Yes.
Did you see that Mr. Carl Greenberg ever filed an amendment to the motion?
No.
Did you see that Mr. Greenberg ever asked for a continuance of the motion for new trial hearing?
No.
Did you see that Mr. Ponder's hearing was ever set for a status conference?
No.
Did you see any filings by Mr. Greenberg after his 2005 entry of appearance?
Not by Mr. Greenberg.
Did you ever see a motion to withdraw as appellate counsel from Mr. Greenberg?
No.
Okay, that's all I have, Your Honor.
Mr. Armstrong, you have the interesting opportunity to cross-examine Mr. Hurt. But you are a stickler for relevance, so I know you're going to keep it to the Ponder case.
Well, I'm actually going to decline that opportunity because there's no additional information that needs to come.
All right.
I certainly welcome any questions from the court.
I have a question that you don't need to answer here on the record, but I would like you to share with me by way of an email and certainly copy Mr. Armstrong if your work uncovered other cases that I think the term you used was languished. If there are Fulton County languishers, we need to get them out of a state of languishment. They don't need to come to me. And maybe Mr. Armstrong's been diving into that, or jointly you have, but I don't want there to be more time accruing on those.
Absolutely. And I would just point out, similar to what Judge McBurney just said, that if you find somebody who had a pending motion for new trial tell us, don't necessarily write to them in prison to tell them to wait, because we will go ahead and ask for a status hearing so that he can be brought forward and have a public defender here to maybe qualify them if you find a case that has a pending motion for new trial.
Well, better, certainly you can let him know, but if you let me know, I'll get a judge assigned to it. Because I don't know where you turn I am not the keeper of all the old cases. It is a pure coincidence that Ponder and Singleton landed in the same place, in the same way that it was a coincidence with some of the other things I've had to deal with. But we can find judicial homes so that steps can be taken. And I know you have been very active in that space.
Well, the problem is, and I apologize, wait for the objection. I found so many cases like Ponder in the sense that Greenberg did nothing.
We're just talking. This is, in fact, Ms. Rivers, we're off the record now.
And then the trial court dismissed the motion for new trial because the defense did nothing, when it was Greenberg that didn't do anything, not the defendant. So that's why I wrote Ponder to go ahead and do this before the judge dismisses it.
Okay, so there would be a category of cases there'll be cases that fall in that category because it's still the same judge. No one was going to be dismissing this because it was a Brogdon case, and then when that docket moved to whoever the next judge was, it was clearly not on anyone's radar. That's part of the issue that caused this unacceptable delay, because in the mind of the new judge, if the trial happened, well, I'm not digging around in that space. So I'm going to extend the same request. If you find scenarios where either there's not been an amended motion for new trial, or the motion for new trial was dismissed, well, but I can't really take action there. That would, a defendant would need to file something. You may want to bring it to Mr. Armstrong's attention, but if a judge said, I'm dismissing what was effectively an unprosecuted motion for new trial because Mr. Greenberg did nothing, proactively, a judge isn't going to do something there because there was a ruling. I was thinking of the category of the amended motion for new trial. No, the motion for new trial was still just sitting there and nothing had happened with it. Those need to be reassigned and actively dealt with. And there are steps the state can take to get it moving along, but more importantly, we need a judge on it, because then that judge, if the case is new enough, rattles GPDC's cage. Although you're operating in a space where the cases are so old, GPDC doesn't provide the attorney, hence Mr. Winchester. So it's an invitation if you want to see things start to move on those cases, if you've found some. But that other category where a judge said, I'm dismissing it because you clearly aren't interested in pursuing it, a defendant needs to take another step before that would hit a judicial radar.
Your Honor, may I add something that if it has any application to any of the cases that you saw? The legislature just passed a law that basically gives courts the authority that they used to have before Cook to grant an out-of-time appeal. Now, that was available to people for many, many years. So for older cases, I don't think it would matter. But part of that is that there's an amnesty for those cases that got dismissed following the Cook case because of Cook. And so for 1 year, those can be revived. And so, but it's specific to those that I believe that were dismissed because of Cook.
Right, those are newer and probably aren't the kinds of things.
Well, there was older cases that were dismissed because they were proceeding under an out-of-time appeal. And so they had not been resolved, but there was an out-of-time appeal grant at some point in the procedure. They were dismissed following Cook.
Right, Cook came and people said, I can just get this off my docket for Cook.
We had to, because that was preventing defendants from going to habeas and distracting them from getting possibly back onto the direct review process.
Okay. Invitation stands.
And so I will send it to Mr. Armstrong and also to Mr. Hewitt. And it could be addressed by the court if the court granted my writ for mandamus.
We'll see. All right. Friday the 13th.
Good to see all of you again. Thanks.
Same.
Yeah, it is.
Yes, sir. Mr. Winchester, any other witnesses? Mr. Ponder?
Yes, Your Honor.
Okay.
Do you need to officially tell Ms. Rivers we're back?
Yes, Ms. Rivers, we are back on the record.
Yes, I'm back on the record.
Thanks. So, Mr. Ponder, time for you to unmute.
Yes, ma'am. Yes, ma'am.
Everything okay, Mr. Ponder?
I couldn't hear you. I think it's up too loud.
Can you hear me now?
Yes, sir.
Okay, just want to make sure everything's okay on your end.
It sounded kind of muffled. Hey, Miss Wise.
Can you?
Is that normal?
It's like they're having a party back there. Okay, well, I don't want them not to talk to each other, but maybe they keep it on that side. How far did you get in school? Oh, that's a lot better.
Oh, for him, it's good. I can hear it. It's good. Hello?
All right, can you hear us?
Yes, sir.
Great. Well, we're going to get started in just a second. We got to close one door. Thank you, Deputy Gordon. All right. We are ready for direct examination of Mr. Ponder.
Thank you, Judge. Mr. Ponder, could you please raise your right hand? Do you solemnly swear that the testimony you're about to give before this honorable court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right. Thank you, sir. Can you introduce yourself for the court reporter?
My name is Robert Ponder.
And are you the Robert Ponder that was convicted in Fulton County indictment 2004 SC 16724?
Yes, sir.
Now, do you remember communicating with your trial counsel after you were sentenced in this case?
Yes, sir.
How did you do that?
By letter.
Okay.
Writing letter.
When did you start writing letters to Miss Good?
When I got to my first count.
Okay. And did the letters you wrote focus on understanding the next steps in your case?
Yes, sir. Generally?
And if you had to quantify how many of those letters you sent to Miss Good, could you put a number on it?
No, it was more. It was a few.
Okay.
I can't necessarily recall how many.
Is a few more than 5, less than 5?
It's probably around 5.
Okay. Did you, prior to getting sentenced in the case, did your family have maintained communication with Miss Good's law office?
Yes, sir.
When you went to prison, did you ask your family at any time to continue communications with Miss Good about the case?
Yes, sir. As far as I can recall, yes, sir.
Okay. Now, did you learn that in 2005 you received a new appointed attorney to handle your appeal?
Yes, sir. As far as I can remember, I do remember that.
Do you know who that person was?
Carl Greenberg.
Okay. How did you know that he had been appointed?
She wrote me back and told me that she was gonna step off of the case, and I think in the letter, I can't really remember. I don't have the letter, but I think in the letter she had told me that he was going to be appointed.
So
But
I'm gonna ask a question a different way. Did you learn that Mr. Greenberg had entered the case from Mr. Greenberg or from Ms. Good?
I want to say Miss Good.
Okay. Do you recall receiving any mail from Mr. Greenberg?
No, sir.
Did Mr. Greenberg send you a copy of his entry of appearance into the case?
Not that I can remember.
Did you ever have any phone calls with Mr. Greenberg?
No, sir.
Once you learned that there was a new lawyer in your case, did you make attempts to contact that lawyer, Mr. Greenberg, from his appointment in 2005 until our present motion for new trial here today?
As far as letters, but I can't really recall how many, but I've reached out.
And when you reached out, what did you ask?
Just trying to ask about the updates and what the process was as far as getting back in court.
Okay. Did you ask your family to reach out to Mr. Greenberg as well on your behalf?
Not necessarily. I mean, I asked my mom, but I wasn't pretty consistent with that. I was really like going through a lot at the prison. It was always a lot of situations taking place, so it was kind of difficult to keep communication going like that.
What does that mean, Mr. Ponder? What kind of situations?
Well, I was at a dangerous camp, and so it was always locked down, and we'd be in the room a lot.
Okay.
So it was
In those circumstances, did you have access to the law library or mail or anything like that?
in those times, no.
Okay.
You don't have access at those times.
Did Mr. Greenberg ever provide you a copy of the transcript of your trial?
No, sir. I actually requested for a copy of my transcript after I came out of trial. Like after I came to my first camp, I filed for a motion for my transcript.
Who did you said you filed a request. Who did you file that with?
I filed it to the courts.
Okay.
I think the county clerk.
Other than writing the court, writing your lawyer, and having your family reach out, were there any other attempts at communication you made to follow up on the status of your appeal?
As far as filing motions or as far as communication?
Just anything you can think of. If there's something that you did that I haven't asked about, now's the time to tell the judge.
Yes, but like I say, it's been so long. I just didn't understand the process as far as what was to be made of not being heard or not being responded back to. So
Is it fair would you agree with me if I said that you were relying on your lawyer to handle the case and do his job?
That's what I thought he was supposed to be doing. So I was actually, yes, that's true.
Did you rely on Mr. Greenberg to handle your case?
Yes, sir.
Was there a time where you received a communication from another attorney, David Hort?
Yes, sir.
And what did you do based on that communication?
I didn't really understand what he was asking, so that was my reason for writing back to get some clarification as to what he was asking me to pursue.
When you wrote back to Mr. Hort, what did you ask him?
I was assuming that when he was saying to testify, I thought he was asking me to testify in the case of the person that he introduced me to. And at the time I was trying to understand what he was asking about a subpoena. So I wrote him about that, and he wrote back and said that I was a part of a large number of people that were sentenced and had been appointed to Mr. Greenberg, and our cases had not been handled.
Objection, Your Honor. At this point, it's just hearsay, and I don't believe the specific information is relevant.
Okay. So let's focus more on your client's situation.
Okay. Did you write Mr. Hort for any advice about how to get a hearing and proceed with your appeal in your case?
Yes, sir.
And based on your response from Mr. Hort, what did you do?
I wrote the motion for out-of-time appeal, and I wrote a motion for an appellate attorney.
Okay. And other than those motions that you filed, did you write any letters to the Fulton County Public Defender's Office or to the clerk?
From what I was understanding, I was already in the process of writing, so I was thinking that this was to be the case as it is now, being appointed an attorney to help me figure things out.
Okay. Is there anything about your efforts over this time period that you think is important for us to know that I haven't asked about?
Yeah, I mean, it was just a difficult time. It was like just the case itself, just the whole handling of the situation. It was really kind of depressing, just not being able to understand what was to take place and at what point in the process was I to be received, or to receive any kind of relief or any kind of aid or assistance. So I was kind of like almost giving up, what I'm saying, about not knowing how to handle everything and not being responded to, as I said earlier, when I was reaching out and writing and things like that. And so sometimes I was kind of overwhelmed and just not knowing how to handle this thing. And it's just a lot of pressure, just like I said, at the camp. It was a lot of dangerous situations it was just a lot of stuff going on. So
Have you ever had any communication in writing or verbally with Mr. Carl Greenberg?
As I said, I reached out, but as far
not you reaching out to him communicating with you.
No, sir.
Can you say that again?
No, sir.
Did Mr. Greenberg ever write a letter to inform you that he was no longer practicing law or wasn't mentally fit to do so and to handle your case?
No, sir. I didn't know. I didn't know that. I found it out by Mr. Hort.
All right, that's all I have, Judge.
All right. Mr. Armstrong, do you have questions for Mr. Ponder?
Just a couple, not many.
Okay. You have as many as you want.
Mr. Ponder,
Yes, sir.
you testified earlier about letters that you had with Ms. Good about Mr. Greenberg. There was several years between your conviction and Mr. Greenberg's appointment. Just tell me about when were you communicating with Ms. Good about your case, if you remember the time?
It was immediately after I had came to my first count. When I got to Smith State Prison, I started writing her about, the follow-up and how I was going to go back to trial and what the process would be and how much time it would take. And we was communicating in that manner. And
would she write you back?
Yes, sir. She was writing me back.
Okay.
Okay. No further questions, Your Honor. I was just...
Okay. Mr. Winchester, any follow-up based on that?
No, Your Honor.
Okay. Mr. Ponder, I'm going to put you on mute again. We're done with the questions. Thank you. Let me just finish this one note and then I'll keep us going. Okay. Any other witnesses, Mr. Winchester?
No, Your Honor, request.
Mr. Armstrong, any witnesses you want to call?
No, Your Honor.
All right, then I need defense one. I don't know if Mr. Hort walked off with it or if you've got it. And then defense two, you'll email to me and Mr. Armstrong.
Is this the only other physical copy you have in the courtroom?
Unless he walked off.
You also can email me. It might be easier if you just scan, or is it not scan? Defense one.
Defense one is not scanned.
Okay, I'll take it. Thank you. Do you need another copy?
I'm assuming it will be filed, so.
It will be filed. All right.
I generally prefer Odyssey over my own paper.
Good, me too. All right, so I've got D1, we'll get D2. Then Mr. Winchester, is there argument you want to make beyond that you set forth in your amended motion?
The only not issues beyond that have been raised. In my motion, I didn't particularize my theory of prejudice, but there will be a particularized theory of prejudice that's not in the motion. So.
Meaning you're about to give me that?
Yes.
Great, okay.
I'm about to email you, defense exhibit 2.
Okay. I'm ready.
Thank you, Judge, and may it please the court. I'll go ahead and start with enumeration 2. I think that's the big issue is the speedy trial, speedy appeal delay. As we've already alluded to in part, this is a due process claim, similar but not identical to a speedy trial claim under the Sixth Amendment. The similarities are that the Supreme Court uses the same 4 factors. The differences are that the 4th factor has been described as fatal if you can't show actual prejudice. Makes me wonder why the other 3 are relevant to a balancing analysis, if there is any balancing. But nonetheless, that's what it says. So that's the rubric we have to follow. Considering the 1st factor, states conceded the length of the delay. This is undoubtedly excessive. There was a case from 2024 called Harper versus the state where they considered a 19-year delay. The words that were used by the Supreme Court in Harper were extraordinary, long, and troubling. So I don't think there's any dispute that this factor weighs for Parker a ponder and it weighs for him heavily. So then the question is, well, what's the reason for the delay and who's responsible for it? I think in my motion, I wrote that it was the court's failure to timely appoint appellate counsel and effectively manage the post-conviction docket. I think that's true in part, but not completely. The state's response is correct that Mr. Greenberg was timely appointed, but his negligence is a substantial contributing factor to the length of the delay. So I think it's a combination of the management of the post-conviction docket together with gross negligence by appellate counsel. And while we don't have any testimony from Mr. Greenberg, an unavailable witness, I think 20 years of a blank docket with no motion to withdraw as counsel, no, I have a letter from my doctor that I'm no longer fit to practice law. This is an abandonment of a client is what it is. And as a result of that, it's not an intentional delay made by the state in bad faith to hamper Mr. Ponder's appeal. So, that would be the strongest that factor could be weighed against the state, but it nonetheless weighs heavily because court staff, prosecutors, and trial counsel believe it or not, are collectively viewed as the state for purposes of who bears responsibility. So I think the second factor also weighs for Mr. Ponder here. The third factor is whether he invoked his right to a speedy appeal in due course. The record is kind of the binary part of this. It speaks for itself. I could not find, and I'm sure the state will point out, that there weren't any file stamped letters or motions until 2021 from Mr. Ponder. However, I do think that we have credible testimony from Ms. Good that Mr. Ponder and his family kept consistent communication with her until Mr. Greenberg was appointed, and that she informed Mr. Ponder's family that he had new counsel at the time. I think Ms. Good's testimony that she received communications from Ponder corroborates Ponder's testimony that he did make efforts at a minimum to find out what were the next steps, who is my new appellate counsel, and when will I get back to court. I would love to walk in with letters that are dated and mails with stamps, but we don't have that in this case. But I also don't think there was any cross-examination to impeach Good's testimony or Ponder's testimony that there was consistent communication. So considering that unrebutted testimony together with the general rules about not holding pro se defendants to the same standards as attorneys, I think that while this may not be the most vigorous invocation of the speedy appeal right that could be shown, it is nonetheless one in due course.
Plus, this is not a fatal factor. It may not weigh as strongly in your client's favor as you'd like, because he didn't know he needed to be sending letters. This is one that's been labeled, well, if there's been no assertion, none of those years should be weighed as being harmful.
Right. So this is not a case where he fired his lawyer and asked for continuances to get a new one. It's not a case where there was a withdrawal of counsel. This was one lawyer who was responsible for the entire delay, did nothing, didn't happen. Client did what he was supposed to do, relied on his lawyer to do the job. The second part of that process failed him, and I think that this factor should not weigh against Mr. Ponder. Maybe lightly weigh in his favor, but in his favor nonetheless. So it brings us to the ultimate question of actual prejudice. How do you show that a 20-year delay is harmful? And what the Supreme Court has essentially said concerning the standard for prejudice is you got to show a reasonable probability that the outcome of the appeal would be different. My argument in that respect is as follows. Prior to the new evidence code enacted in 2013, there was case law in Georgia holding that the failure to charge on the defendant's sole complete defense, even absent a request from trial counsel, even absent an objection after the charge, was a reversible error so long as the charge as given did not adequately cover the omitted principles. And I'll just put on the record 3 cases that stand for that proposition. The first one is Gray versus the state, 158 Georgia Appeals, 582 Division 2, 1981. This was a case that reversed a criminal conviction for omission of the mistake of fact offense. The second one is Tarvestad v. State, 261 Georgia, 605, relevant language at 606. A 91 case from the Supreme Court that reversed for failure to give justification. And then Price versus the state, 289 Georgia, 461 Division 2, another reversal in 2011 for failure to charge on mistake of fact as the sole defense. Why is that relevant for Ponder? The reason it's relevant for Ponder is that trial counsel's defense theory in this case was voluntary manslaughter. Voluntary manslaughter is a mitigation theory, and if it's a defense to any of these crimes, it's only a defense to 2 of them, malice and felony murder. It's not a complete defense to the indictment. The only complete defense that there was slight evidence to support in this case would have been a theory of justification. And I based that on several excerpts from Mr. Ponder's testimony.
Justification? Okay.
I based it on Mr. Ponder's testimony and then also testimony from the investigator about his interview with Mr. Ponder, and I think it was Mr. Pitts.
There was testimony that the reason he had the gun was that 2 days before he arrived at the apartment for the shooting, there was another altercation between the deceased and the deceased mother, where the deceased mother brandished a knife. And then there is, that was on page 484 of volume 2, 441 of volume 2, and then there is, I think the specific testimony for that is on page 484, where he says the reason he had the gun was because he was threatened.
So I'm confused. I just went through to say failure to fully charge on a sole defense, and when there's only one defense is reversible error. And that defense was, it was provocation, voluntary manslaughter. But now you're saying actually there was a second defense, which would have been justification.
So when I say sole defense, I'm using that term narrowly to refer to sole complete defense. So it was true that his defense at trial was manslaughter, but even if he got everything he wanted from the jury with that, he doesn't walk out of the courtroom. And
Got it. So the sole defense, maybe we'll call it a capital D defense, or you said complete defense, would have been justification if he were justified in shooting 3 unarmed people multiple times. Then he could be found not guilty. And there was no charge to the jury. And you're saying there is slight evidence of that because, and then you've cited to the record where he said a few days before there was a knife that was brandished. I brought the gun because I was afraid I could be attacked.
Talking about yelling, ripping of his shirt during the argument, heated argument over money. So the argument is there is at least slight evidence to support a justification defense. Justification, in the most literal reading of the term, is his sole defense because it's the only complete defense to the indictment. The charge as given does not adequately cover justification because there's no charge on affirmative defenses. There's no charge on, any of the principles that go with that. And the reason it's prejudicial having to appeal this issue now is that in 2013, with the new evidence code, now this would be subject to plain error. Plain error presents several problems for Mr. Ponder. Number one could be a strategic waiver. Ms. Good has testified exactly what her trial strategy was. The second reason, and probably the most important reason, is the change in the standard for harm. To prove a plain error, I have to show not only that it wasn't waived, but that it was supported by the evidence and that it's affected his substantial rights. That's a different burden to show harm than the former version, which was, did the charge as given adequately cover the omitted principle? The answer to the latter is no. The answer to the former, probably yes. So that's when the Court of Appeals and the Supreme Court talk about how does it affect the appeal? How can you show that an appeal would have come out differently if you had done it pre-2013 as opposed to 2025? That's my answer, is that if I raise this as a plain error, I'm going to lose on several prongs. If I had raised it under the old rule, not only is it preserved, waiver, I don't think it would apply, and I don't think there's much of a dispute that the principle's not adequately covered. So I think that, as succinctly as I can put it, the change in the standard for harm in 2013 eliminates arguments that were otherwise available to him pre-2013. And that's why the delay is prejudicial.
What happened so the 2013 changes the new evidence code? There's something in the evidence code that says you use plain error analysis when there's a jury charge that's justified. I know it happens to be justification, but that's justified, but's not given.
I think it is. I think Rule 104 applies to omitted factual objections. 17.8. It's
57.
Yeah, there you go.
What is it?
Colleague has helped me out here. 17.857 or.
And that was amended or created in 2013 as part of the introduction of the new
Correct.
Evidence code.
Right. So, or it's either 17.857 or 58. And what it says is that
objections to jury instructions that are not preserved may still be raised on appeal, but through the plain error standard of review. And it creates this new avenue that imposes a new burden of proof or persuasion upon appellants that was not in effect if you were appealing the same style of omission in a pre-2013 case.
So if this appeal had occurred in 2007, meaning the motion for new trial were heard, granted, denied, whatever happens, then it goes to the Supreme Court, you would be operating in a realm in which Ms. Good's failure to object to, well, failure to request, basically, it's an ineffective claim. It's a failure to request that the judge instruct the jury as to justification, and she could point to, it's not much, but it's slight evidence, those few little nuggets or crumbs, hey, you need to charge the jury on justification. Her failure to do that would not be subject to plain error analysis. It would be subject to what analysis?
It would be subject to the omission of a sole defense analysis.
Is reversible.
To Gray, Tarvestad, and Price cases.
Okay.
And I think the way that fits is by distinguishing manslaughter as a defense to a mitigation theory. Because if you take manslaughter out of it, there is no other defense that's raised. The only complete defense to the indictment would be justification. And when the court reads those cases, you'll see the analysis is incredibly sparse. That we're talking like single paragraph analyses. This wasn't charged. The charge as given did not cover this principle. He didn't have any other complete defense. Reversed. And so that is the benefit that I see to appealing Ponder's case pre-2013, that it's a much different road to hoe, as they say now.
Yep. Okay. It's not that there's a witness who there was this great alibi witness and now he's dead or anything like that. It's this legal landscape has changed.
Right, I mean, the courts reviewed the record. This is a case where we confessed to the shooting. I don't think I could credibly present an alibi. But we have cases where there's admissions and confessions to the act. Your options are mitigated theories of mens rea, like Ms. Good pursued, but they're also
Justification. Sure, I shot the guy because he pointed a shotgun at me.
Right.
That's what we hear often in cases when someone's arguing self-defense, that they admit to all the acts. Okay. Anything else you want to add?
Not on that point. I think that's the coherent theory of prejudice for Mr. Ponder.
Okay. I think I follow it. Do you have other argument to make on other issues, or?
Yes, Judge.
Okay. Well, then I'm gonna have you wait, because I'd like Mr. Armstrong to give me his preliminary thoughts. I will note that this argument doesn't jump out from the amended motion. And so if Mr. Armstrong, your response is, that's interesting, I want to read those cases and I'd like to put something in writing, that's fine with me. You may be ready to speak coherently on it, but I didn't glean that from the amended motion.
Absolutely, Your Honor. I'm actually ready to argue that because I'm familiar with the issues that Mr. Winchester has raised.
Great. I'm ready to try to absorb it.
It's going to sound a little bit confusing at first because I'll be talking about things that are not relevant to explain the situation with plain error review.
Okay.
So plain error review for evidence issues is what changed on January 1st, 2013. I do believe it is 224.1.104 that sets that out. I might be off by a point. But essentially, that applies to the trials that took place on or after January 1st, 2013. So when we do appeals for cases before that date, where the trial took place before that date, I still get to argue this wasn't something that was preserved, this isn't something the court can consider. And so we often go through ineffective assistance of counsel for objections that weren't made. Plain error review does not apply to those pre-2013 cases. There is a wild card. I'm waiting to get to the final one. There's a wild card in there because there's plain error review now for comments on the evidence. And I apologize, that's subsection 57 that I mentioned earlier. That's when the judge makes a comment on it.
Okay.
It used to be that was super plain error.
Right.
And that was changed to basically be on review. It is something reviewed for plain error if it was not objected to. And in the Willis case from 2018, if anybody's interested, 304 Georgia 122, they looked at that and basically said, the way the legislature has passed this, which had no enacting language restricting it, the way that the language of that statute applies, it applies to the review. And so in 57 context, for the comment on the evidence, it absolutely is the time of the review is basically what determines whether you follow plain error or the old rules.
Okay.
However,
but that's not what we're talking about here. It's not Judge Brogdon's comment on the evidence.
Oh, no. There's just the types of plain error that we have going on that are relevant and inform why I'm making this comment. 17858 is the one that instituted plain error review for instructions that were not objected to or reserved. And I'm going to come back to that phrase, or reserved. The enacting language for the change in the law in 2007 basically said it shall apply to all trials which occur.
2007, so it was not linked to the 2013.
No, this is something that happened before 2013, where basically we switched from a much more permissive schedule, which applies to Mr. Ponder, just to get ahead of myself, than what happens now in the sense of how you preserve a claim.
Okay.
And so in 2007, those changes to the law apply to trials that occur on or after July 1st, 2007.
Okay, so this is like the 104 change. The review that might be less favorable for Mr. Ponder wouldn't apply to his trial because it occurred before 58 was amended.
Yes. And
so then there's not prejudice.
So correct. And I'm going to get more into that in just a second. But for the preliminary issue as far as plain error review, it doesn't apply because beforehand, if a defense attorney said, I reserve at the end of the judge's instructions, then any claim whatsoever about the instructions, right or wrong, was preserved. You didn't have to identify anything. You didn't have to object specifically to them. I didn't have a reason to look, so I haven't looked because I was looking at law. I don't know if Ms. Good said that in this particular case.
Okay.
So it might be that Mr. Ponder has the unfettered right to raise any of the claims that he wants to with the instructions that the court gave.
Because if Ms. Good said, I reserve,
yes,
then really what she's done is preserve anything and everything in attacking the jury instruction.
Correct. And that was actually a problem when I first became an attorney and was reviewing attorney performance as an appellate attorney. For a good period of time after that, there were a lot of claims because defense attorneys were so used to just saying, I reserve, that they weren't making specific objections when they even when they believed that they had one. So they'd make an objection at the charge conference, but they wouldn't mention anything other than I reserve at the end of the thing. And that wasn't preserving the case under the new law that started in 2007.
So under 58, as it's written now, this is I'm remembering reading cases along these lines. You need to object during the charge conference. If it doesn't go your way and the judge moves forward and you don't renew that objection, then you can be deemed to have waived the objection.
If it happens now, it's reviewed for plain error.
Right. Now, meaning after 2007.
Correct. If before that you said there might have been some extrajudicial way they get to it, but if you didn't say anything or you specified one specific objection, that didn't preserve other objections. But if you said the phrase, I reserve.
Got it.
Everything possible was reserved.
Okay. It doesn't sound like Ms. Good objected to the exclusion of a justification charge because it doesn't sound like she asked for a justification charge. So the only way we'd be outside plain error review would be if she said, I reserve?
Correct. Well, no, we wouldn't. Plain error review did not exist before 2007, I don't believe. So we only
for jury charges. I mean, the concept of
charges.
plain error review existed, but not for jury charges.
I don't believe so. I believe
Okay.
that started right then. But
Future reference, there's a charge box on the
Oh!
table.
That's delightful.
It is.
So that's what I wanted to get to before. However, the issue that there's a difference between voluntary manslaughter as defense and justification as a sole complete defense, and that this is something that is fatal to his conviction. I would cite to the court State versus Mobley, Mobley. It is 296 Georgia 876. It is a 2015 case. I'm going to read a paragraph from it, and I apologize for reading a paragraph, but this is the Supreme Court quote. We turn now to the question of deficient performance. To begin, we note that the trial court was wrong to find that justification was the sole defense, and they italicized the word sole, urged by Mobley at trial. A review of the trial transcripts, including the closing arguments of counsel, reveals quite clearly that the defense case was not entirely and exclusively about justification. Although justification certainly was the principal line of defense, Mobley's lawyers also had a fallback position, arguing that if the killing was not justified, it amounted to only voluntary manslaughter, not murder. Indeed, in the closing arguments, one of those lawyers pointed to evidence that Mobley had been provoked to kill Tinch, noting that sufficient provocation would render a killing only voluntary manslaughter under Georgia law. In particular, the lawyer pointed to evidence that Tinch had threatened Mobley on the day of the killing and essentially had challenged Mobley to a fight. And the trial court charged the jury on voluntary manslaughter as a lesser included offense of murder. The finding that justification was the sole, again italicized, sole defense at trial is clearly erroneous. And so this is not a claim that would be successful, regardless of when it was raised, because voluntary manslaughter is a defense. Yes, it's a defense that would still have somebody looking at up to 20 years incarceration, but it is considered a defense for the purpose of the sole defense rule. Now, the sole defense rule is basically if the defense only has one defense, even if they don't request it, that is something that the trial court sua sponte is required to instruct the jury to consider. In this particular case, Ms. Good asked for the jury instructions on voluntary manslaughter and received them. And so there's no issue with Judge Brogdon violating the sole defense rule as far as the instructions are concerned. And so there is no prejudice here to the passage of time. The passage of time was wrong. It should not have happened. But this is one for which there is no prejudice.
So let me distill that. Rather than trying to wrap my mind around changes in 07 and 13, et cetera, per Mobley, regardless of the standard of review, meaning if, regardless of what the consequence is now versus in 2004, whenever the trial was, for a judge to fail to charge on a sole defense. This is not a sole defense case because there were maybe two potential defenses. Clearly voluntary manslaughter. That was what was argued and a charge was given. Potentially justification. There may have been some crumbs out there to support a justification charge. But all that means is that there were multiple defenses. And Mr. Ponder got charges, and there are arguments that the charges were deficient. I'll work through those. But the jury was not uncharged on voluntary manslaughter. And per Mobley, that constitutes a defense that is on par with justification, even though, to Mr. Winchester's point, jury finds you guilty of voluntary manslaughter, that still leaves a mark. You don't walk. As opposed to with justification, you go home. But it was clearly erroneous for the trial court to say, hey, justification was the sole defense because voluntary manslaughter, that's really not a defense. That's some kind of mitigation thing, and we're not going to call that a defense. Is that a fair summary of sort of where we are?
Yes. Essentially, Ms. Good focused on voluntary manslaughter, asked for voluntary manslaughter, got voluntary manslaughter instructions. And so
So it may have been, I'm interrupting, but because I want to make sure I'm still holding on to, it may be that Mr. Winchester wants to amend his amended to say she was deficient for not seeking a justification charge, but Mr. Ponder is not disadvantaged by the passage of time by having forfeited the, hey, back in the old days, it's reversible error when a trial judge doesn't charge on a sole defense, because it's not automatically reversible error. Now, it could be subject to plain error review. That may be a correct analysis of the impact of the change in law, but this case doesn't fit into that paradigm because Mobley says, contrary to Mr. Winchester's argument, heat of passion, voluntary manslaughter is a co-equal when we're talking about sole defenses with justification. And so the jury was charged, and Mr. Ponder happened to have more than one defense, and one of them wasn't pursued. What am I missing in trying to distill it that way?
I don't think that you're missing anything, but I would just like to add that regardless of whether she preserved something, asked for something, whatever, the review of this trial has not changed in any respect with that based on the passage of time.
Because it's not a sole defense case.
No, because the law on jury instructions was prospective. It was not retrospective. So he's saying that he was denied his review. So he's basically saying in 2006, the review of this case would apply one set of standards,
right,
whereas now they apply a different set of standards.
Right.
That's not correct. The original set of standards that applied from the date of his trial is what will apply. And so there's no prejudice from the period of time. Now, I will point out, and I don't have something to cite to the court automatically, but because I've dealt with other cases like this before, when somebody overrules a decision, where there's a decision out there interpreting something and a court overrules it, people have claimed I should have gotten my review earlier because of that rather than later. I know there was a case that I had with Judge Glanville where this came up and where the defense attorney was John Krause. I wish I could remember the name off the top of my head. Where there was a 14-year delay and some law had changed in that period of time. The appellate court said very clearly, you're not entitled to bad law. And so if it was overturned because it was wrong, that doesn't mean that you're entitled to that.
Got it. If I had been able to have my appeal back in the era of the bad law, there would have been a different outcome. Correct. And that case has been, okay, I understand that.
But I don't think that's what Mr. Winchester is arguing. I just wanted to point out that thing because that is a situation where something will have changed in the law and defendants will argue that they should benefit from what was prior to that change.
Okay.
But that's about the decisions and whether the decision was right or wrong.
So your most fundamental point is whatever the standard of review was for omission of charges on defenses in 2004, 2005, that standard of review would apply today. Correct. Anyway. You don't forfeit a more favorable standard of review because the law changes later on.
Correct. The only thing I'm aware of that would be different is the review of an alleged comment on the evidence because of the particular way that was passed and written.
Right, and that's 17857, which doesn't come into play in this particular case.
Correct.
So the whole point about Mobley was just, by the way, Judge, this isn't a sole defense case. Well, justification isn't the sole defense.
It's two bases. The review hasn't changed, but also the law is against the claim itself.
Got it. Okay. And what is the case law that says, or this is where you're saying I don't have it in front of me, that says when the standard of review changes, it's not retroactive. A defendant is entitled to the standard of review of an alleged error that existed at the time the alleged error occurred, or the error allegedly occurred.
So I'm reading for, I apologize, I need to go back to the other one. Am I in the correct one? No. Basically, it is the enacting language for the change in the law, making it plain error review. As far as the 2013 change, that was very, very clear within that law. That law very clearly says January 1st, 2013.
Okay.
I'm going to 17858, and I can access the change in the law that took place in 2007. Section 5 of 2007 Georgia House Bill 197 reads, "This act shall become effective on July 1st, 2007, and shall apply to all trials which occur on or after July 1st, 2007.
Okay.
And also, there's state constitutional issues about retroactive application of things.
Right. Well, that's why I figured there'd be a case that says.
I'm sure that there's additional cases,
Okay.
but the reason that the case law is the same, and I had to deal with this much more frequently at the beginning of my career when it was much fresher and everybody's in all the cases, was because there was two different standards. There's a standard before that change, and there was a standard after that change, which is one of the reasons why I took this case rather than have it to the assigned attorney who never had to deal with these laws before.
Right. Okay. All right.
Just not something that people practicing today encounter often.
Nope, we don't. And I'm impressed with the work Mr. Winchester's done on this as well. So Mr. Winchester, anything you want to say? I'm less interested in the Mobley opinion and whether there were two defenses or one. I'm more so on this notion that whatever changes were wrought by the amendment of 17858 or the evidence code 6 years later, they are all prospective in nature, such that whatever standard of review existed at the time of Mr. Ponder's trial, better, worse, or identical, I would be, and any appellate court would be required to apply those to the issues that you're identifying.
So I'm not going to dispute Mr. Armstrong's reading of what the bill says. If the bill says it's prospective, then it is. I looked back at the record while we were talking, and I see that Ms. Good did reserve her exceptions. She does that on page 578. So I think, but I do not think that the non-retroactive applicability of 58 is dispositive, actually, because of the Mobley opinion. And maybe this is where we get into the deep water of this issue, but the Mobley opinion says what Mr. Armstrong read, but there are no citations. It's not relying on anything for that statement.
But it's the Supreme Court, they get to do that. They get to write a sentence and say, this is the law.
So they do, but if they do that for the first time in 2015, then Mr. Ponder could still have gotten the benefit of my interpretation had he appealed prior to the Mobley decision. So I think that actually plays into my theory of prejudice, even though the language of it is bad for my argument.
Okay, I hear you, but was Mobley overruling anything, or was Mobley for the first time answering that question of does voluntary manslaughter really stand shoulder to shoulder with justification or duress or whatever you might call a complete defense?
Well, I don't see any notations overruling the case.
So would the rules of interpretation and application be, that's the Supreme Court telling us what the law has always been and will continue to be until it is reversed, or that will mark a change in the law?
I think if it was clarifying what the law had always been, there would be some citation to mark the foundation for what they're carrying forward. They don't say that they're setting out a new rule. Maybe the reason that they don't is because it's through IAC. So they're talking about what trial counsel, what were the objectively reasonable standards that it had to follow at that time.
Right.
I'm going to take a position in this argument that this is, to the extent this is an unequivocal pronouncement resolving this issue against me, it didn't exist during a decade where Mr. Ponder could have benefited from my interpretation.
Yep. And there would have been a different Supreme Court. Who knows what they would have said? Not that changing the composition of the Supreme Court means they're going to change their opinion.
Your Honor, I may amend a statement that I made previously.
Sure.
The case that I mentioned that I had with Judge Glanville is Terrell versus State. It is 313 Georgia 120. They did not say the thing as explicitly as I mentioned. They decided on a different issue.
Oh,
They decided that factually the claim would not apply, but the issue was there used to be one issue with if the judge denies a cause for strike that they should have granted, what would happen. In 2018, that law changed with a Willis decision in the death penalty case. And so this person was saying that I should have had the review before that case. I made this argument there. They discussed that argument, but then they went with, but factually the juror wasn't somebody who should have been excused.
got it.
So I wanted to amend that because I said that they had ruled one way when that was more advantageous for me than
It really is.
it really is.
Okay. Okay. Tell me what you want to talk about next, Mr. Winchester.
Paragraph 3 is a short allegation about the witness intelligence factor. The state's right that this standing alone is not a reversible error, but it has been disapproved as not the right practice.
Right. I thought we're not supposed to do it anymore, but again, disapproval as opposed to you say that word and
Right. So
new trial.
not reversible standing alone, but I think given the other things that are floating around in this case, it does add some splash tinge of prejudice under a cumulative error analysis.
Which
And-
didn't exist back when you would have had your appeal. So do we do a cumulative error analysis?
Good question.
So if we're talking about at the very end, if there's cumulative error about ineffective assistance of counsel in trial court errors, then yes, because that's the review that occurs now. Because that's the case law decided that that was improper to say that that couldn't happen.
Yeah.
But as far as whether the issue is the delay in the case.
Got it. This is a way where it's been beneficial to Mr. Ponder, is that we can think about cumulative error. I would think he wouldn't forfeit positive development in the law, like positive meaning better for a defendant, that now we're required to think about cumulative error. But so I got it. But that's not a benefit he would have had you been pushing his appeal in 2007 or 8.
Right.
Okay.
So I think there's 2 points with the witness intelligence paragraph. The first one is what we just discussed about how it contributes to cumulative error. The second is there is an enhanced danger for harm in this case from this instruction because one of the state's ballistic expert was Bernadette Davy, who I haven't admitted evidence in this proceeding, but she's dealt with several significant ethical problems since admitting that she gave testimony under oath for reviewing firearms and ballistics that she didn't actually review. I haven't proven that she did that in this case, but if we look for a nexus between the bad charge and where's the danger for harm, I think that the court can take judicial notice of her ethical problem and use that as an enhanced risk for why this charge would have been harmful to Mr. Ponder. But that's all I have at that point.
Okay. Now I wasn't seeing the connection, but meaning in theory, an expert, gosh, this witness intelligence, she knows all this stuff. And so we're going to give her statements enhanced credibility because she has that aura of, let me tell you, here's how a gun works and the striations on the projectile and this and that. And that's something that would add to the adverse impact of instructing jurors about thinking about witness intelligence.
Correct, and a potential for enhanced credibility for the testimony of an expert who has now admitted to give falsifying testimony as to some of the things that she reviewed in prior cases.
Okay.
We don't know specifically that Mr. Ponders is one of those, but his trial did occur during the time period that she recounted.
Okay.
But that's all I have with that.
All right. You can keep that's short enough. I can keep up with that and whatever you're going to say next, and Mr. Armstrong can respond later.
I'll just close on one point with ineffectiveness. I've kind of gone over in my head about whether I'm going to continue to pursue subsection B. I ultimately, for some of the reasons that we've already talked about laws changing and getting the benefit of a now overruled case, that's what I was trying to do with this, but ultimately for some reason, I don't think we can prevail on that, so I've got to withdraw 5B.
Okay.
But I will go forward on 5A. Ms. Good's testimony was that voluntary manslaughter was the defense here. She did request the pattern jury instruction, but she did not request any of the non-pattern language that has been around for several decades that explains the link between certain factual circumstances and when sudden provocation occurs. And there are three pieces specifically that I'm referring to, and I'll kind of find it. I'll read those into the record. Okay. First quote is from Williams versus the State, 245 Georgia Appeals 670, Division 1, a 2000 case.
Can you give me the numerical citation again?
Yes, 245
Yeah.
Georgia Appeals
Okay.
670,
Yep.
Division 1, a 2000 case. We have held that heated arguments, physical beatings, and fear of some danger present sufficient provocation for voluntary manslaughter. I think that was factually applicable to her theory because this shooting arose from a heated argument over money, and there was a fear of some danger introduced when Mr. Ponder testified that the reason he had the gun was because 2 days prior to the shooting, the deceased's mother brandished a knife to force him out of the apartment. So those two things together, I think, create slight evidence for that charge, and that it kind of creates a visual nexus for the jury about what, not just what provocation is, but what it can look like as applied to facts in the case. There were also.
And are those pattern charges? So people keep saying the standard charge or what, but there's a pattern on voluntary manslaughter, and it sounds like Judge Brogdon gave that.
Correct.
What you are arguing Ms. Good should have done is to have submitted a customized charge, non-pattern, but anchored in case law, saying, let's talk a little bit more about what provocation or heat of passion means. It can mean and rattle some things off.
Exactly.
Okay.
The pattern charge was given. She did not fail to request that. That's in black and white, but there was favorable, in my opinion, non-pattern language that could have addressed her theory of the case and what I think provided a good illustration favorable to him. The other excerpt is about infidelity. There was issues of infidelity in this case between Mr. Ponder and the deceased that contributed to the arguments they were having.
Okay.
The discovery that a partner has been unfaithful, whether
Is this from Williams or now in a different case? All right, what's that?
This is Strickland versus the State, 257 Georgia, 230 Division 2, 1987. The discovery that a partner has been unfaithful, whether the accused sees evidence of infidelity or hears about it from the unfaithful partner or another person, can amount to sufficient provocation. So I think the evidence that supports that was the testimony that she had been fairly open about having been on the side, and that when the shooting in this place took place, Mr. Pitts, her then boyfriend, was actually in the room. That's how this part of how the shooting occurred.
I thought Mr. Pitts was mom's boyfriend.
Yeah. You might have been confused by my brief that changed everybody's names.
Maybe.
Yeah, but
The part about
I will follow the transcript. Trust me. I'm not disagreeing. My brief digestion of it was that the gentleman was actually mom's boyfriend, but
if I confused that part, then of course I accept that. But
But there was clearly evidence in the record that there was tension over infidelity.
Right.
I'm not pushing back on that.
Right, so I think that's the anchor for that charge.
Okay.
And then the final one is from Washington versus the state, 249 Georgia, 728, Division 2, 1982. The quote is, "The issue of whether a reasonable person acts as the result of sudden irresistible passion may be raised by words which are connected to provocative conduct by the victim." So I think the three of those quotes were supported by the evidence and would have assisted the jury in understanding how this applied to Mr. Ponder's defense. And given that first verdict form, I think it shows how close of an issue, at least mens rea, was for the jury as they deliberated. And,
Right.
you know, where the issue is close, even small omissions can make a difference.
Got it. No, it was, they checked the box on the first verdict form. Okay. All right. Anything else, or that sums up your oral argument in conjunction with your written brief?
That's all I have, Judge.
Okay. So, Mr. Armstrong, we've got the cumulative error flowing from the witness intelligence charge, and then whatever you want to say about Ms. Good's alleged ineffectiveness because she didn't ask for more than the pattern for voluntary manslaughter.
Absolutely, Your Honor. The ballistics issue and the GBI witness that the defense has indicated has concerns. I'm not familiar with that particular issue, however, with that factual issue. However, this is a case in which the defendant spoke with the police and admitted that he shot all three of the victims. And this is a case where he got up and testified, said he did not have authority to enter the building, and that he shot all three individuals. I don't know how a GBI ballistics expert who testifies about the ballistics informs that. Perhaps there's some nuance to it that I'm just not thinking about at this moment. But as far as he was the shooter, that's an uncontested point. And so I just wanted to mention that as far as that is concerned. As far as the ineffective assistance of counsel claim regarding the failure to ask for non-pattern instructions for voluntary manslaughter, I'm not aware of a standard for attorney competence that requires an attorney to find additional charges when a pattern charge sufficiently addresses the law on an issue. Yes, there are factual circumstances that case law has addressed about standards and different things, but typically courts aren't encouraged to give juries instructions on the specific facts of cases. And so I don't have a case ready for the court that says that nobody's ever ineffective for failing to ask for a non-pattern instruction, but I would just say additionally that that is a road I would be loath to go down because I'm so busy trying to get people to go with the pattern instructions.
Right. And there are an infinite number of permutations. If suddenly you're ineffective for not having come up with this non-pattern versus that, it's limited only by the creativity of the appellate lawyer, who makes a good point that it would have been helpful to ask to see if the judge would amplify on these things. Don't know that the judge would have, but it's not a challenge to the judge's charge. It's a challenge to the lawyer's performance.
Correct. And one of the things that's a through line on the appellate decisions regarding ineffective assistance of counsel is that the question is not whether current counsel has reached a better way of addressing a claim or a better way of presenting a defense. It is a focus on the defense that was made and the trial counsel's decisions at the time. And trial counsel was absolutely reasonable in presenting her voluntary manslaughter defense to present that with the pattern instructions on voluntary manslaughter. I did not note any issue with the voluntary manslaughter instructions that made it deficient or made it incorrect. They are reserved, so they can be raised on appeal if there are some. But there's nothing that I see that would indicate that Ms. Good was anything other than a completely competent advocate following her client's interests.
Got it. Mr. Winchester, I want to make sure I am not missing anything on the prejudice piece to your speedy appeal claim or violation of the speedy appeal rights. It is connected to the change in review that Mr. Ponder faces now versus what it would have been, whether it's because there's no Mobley or maybe it is a different standard of review, although it sounds like whatever the review for a failure to charge claim was in 0405 is the one that we'd apply today if we're doing it. But it's all swirling around that. It's the failure to charge on justification as the sole defense or as a parallel defense, however we take it. But that's the prejudice to Mr. Ponder, is how that law has evolved, and we're working in an era now where it's a less favorable appellate landscape for him. And it wouldn't have been had this been timely acted on.
Correct. So there's two pieces. The first piece is that the plain error review standard has changed his burden on appeal. The second piece is if the state's right that that's wrong, that I'm wrong about that, that Mobley is the first instance that the sole defense argument was taken away from what he could raise in his appeal. And so even if he gets the benefit of the old review, he wouldn't have the benefit of the sole complete defense issue in an appeal now, even under the old review. So it's those two steps.
Got it. Okay. Mr. Ponder, we are at the end of the hearing. As I mentioned at the start of the hearing, what I will do now is take this under advisement. I will enter an order. It will either grant the motion for new trial or deny it. I guess it could grant it in part on some grounds, but in the end, if the thrust of the order is no new trial, it may be, I'm amending the sentence, but no new trial, Mr. Winchester will then take your appeal to the Supreme Court, where he can make all these same arguments to the Supreme Court. You will not participate in that in the way you have here. You will not be present. You will not be patched in. There's no witness testimony when that type of argument is made to the Supreme Court. If I grant you a new trial, the state will likely appeal that. That'll go up to the Supreme Court. But if the Supreme Court affirms me and you get a new trial, then we really do start all over again. And you'd come back to Fulton County Jail. I don't know that Mr. Winchester does trials anymore, but we'd work through getting you a lawyer. You'd be appointed a lawyer if it's not going to be Mr. Winchester for purposes of the trial. And that lawyer would engage the state in terms of, do we want to work out a plea? What can we do here? Or is there going to be a trial again? But I don't want to get way ahead of things. That's only if I grant the motion for new trial and if that decision is appealed, that the Supreme Court upholds that. Do you follow all that? You should unmute.
So you were saying that if you was to grant the trial, you could amend the sentence or something to that effect?
So I got a little fuzzy at the beginning. The typical outcome is a judge grants the new trial or denies it, off on. And if I deny it, like I said, you go on up to the Supreme Court and Mr. Winchester will try again with those justices saying, hey, here's why you need to reverse his conviction. If I grant the new trial, it could mean you get a new trial. I could grant some of the grounds that Mr. Winchester has argued about your sentence, but still say no new trial. So there's this middle ground where it's called granting it in part and denying it in part. And so I may end up amending your sentence, but I want to be real clear what that means. That doesn't mean I look at it and say, man, that Brogdon, that was harsh. I'm going to make it 30 years instead of life plus 80. I don't have that authority and I shouldn't do anything like that. But I do have the authority to correct an error. But an error doesn't mean I think the sentence was too high. It means, just as an example, if 2 counts should have merged so that you only get 1 sentence for those 2 counts and not 2, I need to correct that. And if the state agrees, they're not going to appeal that part. But the main point that Mr. Winchester is making is that you should get a new trial, not that your sentence should be tinkered with. Did that better explain my initial unclear explanation?
Yes, sir.
Okay, so that's where we are. Any other questions?
When exactly would I be notified about this process?
Well, it's with me now. I have to find time to write an order that answers these tricky questions. Once I do that, that'll go into the docket and Mr. Winchester will get it and he'll get you a copy of that. Okay, but it's not going to be tomorrow. It's not going to be next week. But it will be a lot less than 20 years from now. Okay. Anything else?
Could you kind of like, so withdrawal of 5B, what ground was 5B?
So Mr. Winchester withdrew a couple of grounds. One of them was a claim that Ms. Good was ineffective because of how she handled the situation when the jury came back with that first verdict and they found you guilty of malice murder and voluntary manslaughter. And what the lawyers did, they talked about it, and I'm confident Ms. Good talked to you about it. And they said, Judge, you need to tell the jury they can't do both. It needs to be one or the other, which is what Judge Brogdon told them. And then they went back and came up with their ultimate verdict. And Mr. Winchester is backing away from challenging the way Ms. Good handled that situation. Okay? And the other one he has withdrawn is that Mr. Winchester, believed in looking at your sentence that this is a different one, that the court had made a mistake because it didn't merge all the gun counts. But Mr. Armstrong pointed out some case law that makes very clear that a judge doesn't merge firearm convictions when there are multiple victims. And the jury concluded that you shot all 3 people. And so there is a gun charge, a firearms charge for each of those 3 victims, and they do not merge. And Mr. Winchester did the right thing. He said, yeah, I see that case. The case says what it says. It doesn't make sense to argue that because all I'm going to do, Judge McBurney is going to say, see this case. But he's seen it, and so he's withdrawing that one.
The charge with the failure of the jury being, I guess, corrected about the verdict, I was never informed about that until I looked at my trial transcripts to see that whether they was informed that they couldn't give a verdict on both charges or not. She didn't tell me about that.
Well, you and Mr. Winchester should talk about that, and that may prompt Mr. Winchester to do some other things on your behalf, but that's a conversation the 2 of you should have, okay? Because you and Ms. Good should have had a conversation about that, and the transcript's going to show what it shows. Your ability to recall 20-something years later what exactly you guys talked about each moment of the trial isn't what we'll control. It'll be what's in the transcript, but the transcript may be silent on that. It's certainly not going to have the record of what you and your lawyer talked about. That would not be in the record. But if you were in court when that discussion was had, then that counts as you being part of the discussion. Okay? Anything else?
No, sir.
Okay, well, I appreciate your patience. I will do my best to move this along. You've been waiting far too long to figure out what the next step is. I want to thank Mr. Winchester again for diving into this one. He did so at my request. He has done good work on this, and I thank Mr. Armstrong for his usual good work as well. If there is nothing else, thank you to the folks at Wheeler for making both Mr. Pritchett and Mr. Ponder available. And I will take it from here. Thanks.
Thank you.